I was basically asked to talk a bit about our work. We basically generated a nonprofit organization, just a little bit of a background. We're right now in Vienna. We have about 5,500 members that pay what we're doing. So we're pretty independent in what we do, and we have a team of about 20 people, some tech, mainly lawyers, that work on all of these enforcement issues that we have. What we do at NOIB is kind of 3 types of cases. We do kind of standard setting cases, which are the really interesting ones. So issues that are, unclear, where there's novel problems that come up. We also now started to do more kind of pure enforcement cases, because what we realized, and what I talk about later a bit more as well, is that we do have law in Europe. We do have GDPR, we have all this regulation, but people just simply don't comply in very simple cases. So we focused on that as well. And what's upcoming, what's really interesting, is collective redress. I will talk about that for a bit as well. Now, if you work in privacy and GDPR, you will realize that there is basically a violation in every corner. So every time you open an app, you will find some GDPR violation for sure. And that makes it oftentimes hard to choose on what you should do or not. A couple of examples of what we did. We usually did a lot on this kind of consent discussion, what you know as a cookie banner. In very simple terms, you can jump off a bridge and thereby end your life. So in a liberal society, you can also click OK and thereby give away your fundamental right to privacy. That's part of having that right, is that you also have the right to give it away. Problem is, obviously, no one is very enticed to click OK on this button here with that picture in the background. So what they do is that they basically make it look like that and then put an OK button on top of it. And that is fundamentally what we call dark patterns. They call it, wonderful word, consent optimization. And basically we worked into that a lot. You can do a lot of research. It's interesting, a lot of these companies also put information like that on their website, where they tell you right away how they manipulate you, give you a course in how to manipulate people, and so on. So we also try to obviously investigate that stuff, do cases like that. We brought more than 500 cases on cookie banners. I'll get back to that later. Another example that was mentioned before was obviously after the Snowden disclosures, we kind of know that all this backbone is somehow intercepted as well. We did have all these cases against US big tech that cooperates with the NSA. Obviously, it's very hard to litigate the NSA, especially in the US. But what is part of what we call strategic litigation is you look in the whole stream of data, where is a target that you can actually hit. And a very simple target in this situation was the company sending the data abroad to the US, because under EU law, you're not allowed to send data abroad unless you can guarantee that the data is protected abroad as well. So you can't go against the NSA, but you can go against all the people giving the data to the NSA. So that is a typical example where we brought these cases. For example, also on Google Analytics, we brought a lot of cases that basically declared them illegal. One other project we're working a lot now is this pure abonnement, this kind of subscription that now Meta is also copying over, where you pay for your privacy, so to say. It's very interesting, a very complicated case as well, because it looks kind of simple in the sense of give us your data or pay for it. But once you dig into it, you realize that, for example, the amount you pay is sometimes 200-300-fold the amount that the data is worth. And then you wonder why you suddenly have to pay 300 times more if you don't want to give up your data than the data that you have. On a legal side, and that is something, for example, where we're right now looking to have more research on as well, the GDPR does not talk about the value of data, it talks about data being freely given. And we know that only about 3 to 10% of people actually want to give consent to online advertisement and tracking and so on. But we know that this system gives you 99.9% consent rate. So it's a bit of a North Korean system in the sense that we know 3%, 10% want a result, but actually 99.9% get that result. Then the question comes up how much that's freely given. Problem here is the regulators basically said that's fine because it's media and we don't want to touch the media. No one does that research. No one looks into what is really a free choice of someone. How does that look in reality? How does the interface, for example, change that? So we're just starting and try to collect whatever we can get on that, for example. Another case that we brought a while ago is now, it was called Target Leaks, was a case on advertisement that is based on sensitive data for political advertisement to basically, it was a German case where, for example, the Liberal Party Depending on if you were interested in green topics or not, would tell you we're a very green party, or tell you cars are really important, we should not stop, we shouldn't regulate cars. So it was interesting because they used this data for targeted advertisement. We're limited to what the GDPR gives us, but for example, here there was a hook in the GDPR on sensitive data where we could actually litigate on that. Some other cases we do is, for example, credit scoring. That depends on the member state in the EU, how much that's a thing. In Germany, everybody knows Schufa and knows it's a thing. In other countries, that doesn't even exist. So it's interesting how under the same law in each member state, systems exist and do not exist, and one country finds it absolutely illegal, the other one finds it absolutely normal, even though we now have a unified law. So credit ranking is a pretty good example for that. That was also interesting because of the accuracy of data, for example. So the GDPR requires that if you generate data about someone, it's actually true. And we looked for an Austrian credit ranking agency, and that's the reason for this picture, and looked at we only got about 100 data sets of people. But we could, for example, get the data set of the richest Austrian, the guy that came up with Red Bull. He's already dead in the data set, he's still alive. But he had a 1 point below average creditworthiness, being the richest person of the country. So you see that some of that does not make all too much sense. We later realized that they calculate this credit score only on 3 factors: your address, your birth date, and your gender. What could possibly go wrong? But companies pay for that, and they don't know that it's bullshit score. And that guy that we had in this case didn't get an electricity contract because his score was too low. Another case that was kind of funny, it's a payment service in Germany, and they didn't just transact the actual payment data as you would do as a payment service. They also had an API to pull all the products you bought, in addition to the final sum of what you have to pay. We had a claimant that actually bought stuff in an online pharmacy, but also in an online sex store. So you could see all the dildos and the sizes and everything she bought in her basically payment service data, which obviously shouldn't be there. That was a nice one. Another one we did together with the Norwegian consumer rights organization was on Grindr, which is a gay dating app. But they had a SDK built in called Mopup that was part of Twitter at the time. And they forwarded the data to at least 170 partners. And they in turn forwarded in a second layer to at least 4,200 something, and then we didn't continue counting anymore. But what was interesting is it gave the exact GPS location of where you are, the fact that you're right now turning on Grindr, and obviously the time when you do it. So it's basically and there was also the ID of the person. So you could basically say that guy is looking for dick at 3 o'clock in the morning at that corner. And that was broadcasted to thousands of advertisers. That even made it partly into US news, so that was kind of a funny one on that side. That's a couple of examples of what we do, but the bigger thing we actually try to do is enforcement. And a couple of general remarks. We just beginning of this year, did a study of data protection officers. So the EU law requires that larger companies have an internal data protection officer. And we asked them a bunch of questions, but for me the most interesting question was, we asked them if a DPA, if a data protection authority, would walk into the door of an average controller, so an average company, tomorrow, they would surely find relevant GDPR violations. And altogether, it's 74% of the people working on that internally saying, yes, you would definitely find a relevant violation at the average company if you walk in tomorrow. If you imagine that the fire official of a company would say, yeah, sure, if you walk into an average company, you would find a fire hazard right away. You would wonder what these people do. And it's interesting because my guess it's higher, but if you work in that, you would probably estimate it lower, not higher. So we do have a fundamental enforcement issue here. We have all these laws, but we don't really get it enforced. This is kind of our live statistic. You can look at all the cases we do on our website, and it's updated every midnight or something, or 3 o'clock in the morning. That is the cases that we have, and all the gray ones here are the ones that are so far pending a decision. The red ones are the ones that we actually lost. So pretty good winning quote. But the big problem is we actually see there's largely non-enforcement. The cases are just sitting around and nothing happens if you find a violation. The problem that we have is we did have this new GDPR, this new law and all of that, but we didn't have a culture change. The legislator said, start doing privacy, but the community didn't follow. And that is a bit our daily effort and our daily work. So there's a different approaches on how we can solve privacy that are discussed. A typical one that all of them love to bring up is education. We need to educate people more about privacy. Problem is, people have shitloads of other things to do. We will not educate them about the details of Facebook. I can tell you, I work or litigate Facebook for I think more than 10 years. I don't know how Facebook fully works, and I've read all of their privacy policies repeatedly. I cannot tell you from these documents what they really do with your data. They're written the way that you wouldn't ever know. And I think even the guys that program stuff at Facebook are probably only aware of their little thing that they work on and not on the whole thing. So the idea of educating people and having informed choices, I think we can educate people generally to make them aware of an issue, just like climate change or something, but we won't get the whole society to really understand and make wonderfully informed decisions. What's a bit connected to it is notice and choice. That's kind of the American approach to all of this. This picture, you can see actually my finger is up there. I took this picture at the parking lot in LA when I got a rental car. And if you get this text in real, it's a cancer warning that under California law, they have to stick on everything that could potentially be cancerous. And it says that this automobile can contain chemicals known to the state of California to cause cancer, birth defects, and other reproductive harm. That's a notice. And then your choice is take the car or fuck off. Walk. That is the notice and choice principle. Guess what everybody's doing? They put more and more stickers on everything, but it's a very faulty regulation. It basically shifts the responsibility to the individual. My favorite, Disneyland in California has the same warning stuck on it. This Disneyland may cause cancer. So that's a bit the privacy idea of writing privacy policies and then having people make wonderful decisions about it. What all of that basically does is it says, it's your fault. It's not us. We shift the responsibility to you. You should have known better. Not really any way of regulation that gets us anywhere, but that's the first kind of rendition we had. As I'm talking at a technical university, obviously there is a lot of encryption and technical solutions. I'm not an expert on that, so I'll just skip that. I'll just mention it exists. Problem is, for many average people, not easy to manage, and to a certain extent, other people will need your data. Someone else will need to know what's your name if you log in somewhere usually, or if you, I don't know, go to a hotel or something like that. So there is room for that, but the question is that the only solution? I'm sometimes saying it's a bit like, if too many people shoot, I would just get a big tank and then no one can shoot me anymore. Maybe we get people not to shoot each other. So there could be these two things. It's a bit like, you know, if you have a robbery, you can say, okay, you want to have a bigger door or you want to have some lock at least, but you also want to make sure that robbery is not really okay. So we usually work on that second side of saying, okay, even if you can, you shouldn't. And that gets us into the privacy law and the options we have. At least in the European Union, obviously, we have the Article 7, the right to private life. And then especially Article 8, the right to protection of your personal data, which is a fundamental right. So it's a constitutional right you have that is above normal law, so to say. And that is extremely powerful. To have Article 8, we're pretty unique. Some countries in the world have that as well. But to have a huge block in the world that has this right to data protection is actually really interesting. And especially from a litigation perspective, it's interesting to bring cases there. What's interesting, it's oftentimes talked down as this crazy right or something we actually, you know, that happened or is a mischief of history or something. This is the votes of the European Parliament when they passed the GDPR. It was more than 90% of the parliamentarians that voted for this law. And it's quite interesting because later the narrative was turned around as like this was somehow a miscarriage. Get anybody to agree on 90%. So that was actually quite interesting. All the member states also voted for it, other than Austria, my home country, because we thought it's not strict enough for whatever reason. But so you see, overall, it has a very strong political backing. The problem is that the kind of implementation of it is not really working all that well. We have huge educational problems. We have a lot of people that we talk to that actually make these decisions in reality. And usually it's very hard to find good people at DPAs, good people in the courts. Most judges that have a case like that on their desk have never heard about that law and have no clue how technology works. Also at the companies, it's very hard to find people that know that. In the NGO sphere, we're the only NGO that really works on that full time. So it's really hard to even get people to understand all of this legislation and how to implement it. There is this whole push against undermining the GDPR. There was a lot of interfaces that every normal person is also confronted with, usually tries to talk the law down. It's because of this terrible law we have to show you this banner. In reality, you have to show this banner because you want to get the data of people, but it's easier to shift the responsibility to the law. So there's a lot of this like reframing that goes on. And obviously we have a lot of novel and issues and problems that make it very hard to kind of capture stuff quickly. So we usually look at the corporate behavior, which is the key issue, is like how do we get companies to actually look at these laws and comply with it. And I have to say already it depends on the industry sector. So in my experience, there's industry sectors that are very used to regulation and used to the idea of privacy. So typically, if you talk to banks, they know that banking data shouldn't be somewhere up in the internet and you don't sell that. Or typically telco companies know that there's some secrecy in communication. That is in their DNA a bit. But tech side, not that easy oftentimes. And there's a couple of things that move into that, which is basically this very aggressive approach by big tech and startups that we see. That is a culture also that came out of the Silicon Valley of this move fast and break things. And one of the things that gets broken is usually the law. The political view is oftentimes that the GDPR is wrong, that all of this shouldn't exist, and there is no ethical agreement on any of this. So usually we agree that you shouldn't kill someone else. But on the topic privacy, there is large disagreement between these companies and at least the legislator or also the general public usually. A lot of the controllers, a lot of the companies follow the crowd. If everybody else doesn't do it, why should I be the first one to comply with all of this? So you usually see that factor. There is oftentimes a missing demand and supply to actually have compliant solutions. I was just talking to one colleague before on Microsoft 365 because there was a decision today. And you see that even Microsoft does not provide a fully compliant product because they know people buy it anyways. They don't go anywhere else. They don't have another option to go to. So we're just going to produce whatever we do in the US and don't apply and actually apply the local law and comply with it fully. And that also connects that compliance is sometimes a financial loss. Complying with fire safety standards is a financial loss because you don't get money out of fire safety usually unless your whole thing burns down. But for most people, it's a financial loss. And that is the factors that usually lead to a situation where we pretty much have a bit of a spiral down. I sometimes compare the situation also to kind of this wonderful picture of a favela in Rio. I was actually on this gondola, so I took that picture back then. And a lot of what we have right now is a bit that situation. A lot of the technology that we have right now is just built without the code in mind. Just someone built it somewhere on top of something else. And it's very hard now when we have a new law to suddenly say all of this should now be up to the building code. No one wants to do that. And that is another big resistance to actually have enforcement in any way. Because you would basically, if you say, okay, all of this has to be according to whatever building code applies, you probably have to bulldoze most of that. No one does that. So we're still in this like wait and see moment where we just basically don't comply with that. Usually when we have on general theory of law, we usually have the general deterrence why we have law or why people comply with the law. So general deterrence is usually that there's a positive general deterrence where people just trust the legal order and learn from the decisions that you have to comply and you basically just, that's part of enforcement why it works. And the negative part of that is the feeling of enforcement. So basically you have the feeling someone could get me, so I'll do that. Typical thing is you publish decisions or you do public relations and so on. If you look at publication of decisions, for example, the Germans that are usually the forefront of privacy, none of the authorities publishes their decisions. We don't even know what these data protection authorities do in their whole day. And that's interesting because all of them are also in charge of freedom of information. So the authority that is usually in charge of freedom of information and privacy does not publish what they do. The other part that we have is individual enforcement. So for an individual person, if you have enforcement actions, you have this typically idea of kind of reintegration into society, which for companies, I'm not sure if that's accurate. hence the asterisk. And usually on the negative side, you have the protection for others. So if you enforce stuff, you basically have these consequences. That usually is a big part of penalties and, for example, processing prohibitions to say you have to stop that. I'm not saying we need 100% compliance. No liberal society has 100% compliance with any law, but it should be somewhat closer maybe to what the law prescribes. So we may not really get the full speeding limit, but you know, if you get down to 30, that would already be a big step. And we need for that a lot of evidence in corporate behavior, and that's really interesting because we try to find more about that. Very little research on that. There's a lot of like behavior of individuals and how they make decisions and so on, but how companies are actually deciding to comply or not comply, not that much, and not that much that would be helpful for our situations. Now, if we do enforcement, we have a couple of options, and I would quickly go through them. The obvious one is you go to your national data protection authority. So each EU member state has a data protection authority. We pump 300 million euros into them. And Germany alone is 100 million because they have 17 because they're federal state. And if you end up, and the first data protection authority I've actually gone to, other than Austria, was this one. This is the Irish Data Protection Regulator. And to be precise, this is the supermarket, this is the regulator. We put this picture all over the media. Now they got a new fancy building in Dublin, and we tried to get rid of this picture. But at the time when we started, this door here regulated Microsoft, Facebook, Google, Twitter, LinkedIn, you name it. Basically anybody that was not in Luxembourg, which is the other place they all go, was regulated here. And why do they all go to Ireland? The EU can pass legislation, but it does not do the enforcement of the legislation. It doesn't have an executive power in most parts. So you pick the one executive that is not going to do the job, and you end up, for example, in Ireland. How does that look in practice? We had one case that we won against Facebook, and the European Data Protection Board, which is kind of can give orders to that local office, told them to issue a proper fine. And one factor to take into consideration for the fine is how much profits they made from the illegal processing of data. So at least you should skim off the profits they made, not talking about an actual fine like a negative, just skim off the profits. Now, this is the maximum fine under GDPR. This is roughly how much profits they made. So we know how much profit they made on advertisement. The thing was behavioral advertisement, so it has a little bit less than that, but somewhere in that area here. This was the fine that was actually imposed. So you can calculate that they made a huge profit even when they were caught and there was a fine. So the learning is, let's just wait for 5 years. This was not even paid so far. This is on appeal. And you see that even the options that they had, the requirement was do the maximum and include this. They just didn't do it. And there is no enforcement option to actually have the local regulator to do that. A big part of all of that is procedure. So I know it's fucking boring and every lawyer even hates it. But you can have the most wonderful rights. If there is no place to go to enforce your rights are null. And that is a big part of the GDPR problem is we can choose actually the jurisdiction we go to. So you can go to the residence of where the data subject, so the user sits, the workplace of the data subject, the place of the violation, the main establishment of the controller, and so on. So we usually do that as strategic litigation, that we go to the authority where we think it's the most likely that something actually happens. And that also determines the jurisdiction for appeal. So usually you have to appeal all of that, so you end up in court even if you were at that authority before that you thought is going to be useful. We don't have a harmonized procedure in the European Union. Every country has a different procedure, and they should now cooperate and work together. And to give you some highlights, for example, the Belgian DPA, they basically hate each other and are almost impossible to get anything done. The Austrians allowed fixing during the procedure, so you have a procedure and after 1 year of it, they fix the problem and then your case is gone. You never get a decision because they fixed it by the end of the procedure. Germany basically negotiates with the companies just like they're partners. We now got emails where they have meetings together to improve potentially the compliance with it. There is no publication. The appeal in Germany costs about 2,000 to 10,000 euros, depending on where you are. So you have a free right to complain, but if the authority doesn't deal with your complaint, you have to pay 10,000 euros to get your free complaint dealt with. That is the reality of the free complaint, so to say. In Spain, it actually works quite well, I have to say, but for example, they require that you submit anything with their national Spanish signature, with their electronic national Spanish signature. So we had to go to the Spanish embassy. It took us about half a year to even be able to submit something at this system. In France, they have the view that you're not even a party to your own rights, so you have a fundamental right to privacy, but you're not a party before the regulator because you are not part of your own rights for whatever reason. In Ireland, we know that about 99% of the cases are not dealt with. So we know they have about 10,000 cases a year, but about 8 decisions a year. Do the math. So you have a fundamental right, but 99.9% of the time it goes to the trash. In Poland, they also require a national signature, but what's even funnier is we actually wanted to have access to our files, so the answer of the other side. They told us, yes, you can have that, but you have to come to Warsaw. And if you come to Warsaw, make sure you bring a camera phone with you, because we don't have a copy machine. And then you get per case 20 minutes to photograph the shit out of your file to actually get the copy of what the other side has said in your own case. That is how this is working right now. Funniest thing, they also require an electronic signature to submit your case, but then they print it out and put it into a paper file. And that is how digital laws are enforced on the ground then in reality. We can go on, but it's basically stuff like that. It's all over the place. There is usually no deadlines nationally, so they can oftentimes just take forever to make a decision. They usually bypass deadlines if they are, because they just invent new steps that the law doesn't foresee. So we usually have a lot of problems in that. You can appeal all of that, but the inaction usually pays off for a data protection authority because the access to courts is extremely limited. There's high costs, so a litigation in Ireland costs about 100,000 euros baseline. If we talk about the data transfer litigation we had, the Schrems 1 and Schrems 2, Schrems 2 cost about 10 million euros in legal fees in Ireland. And I was personally liable if I would have lost the case. Only good thing is there was no enforcement agreement between Austria and Ireland, so I was like, if I ever go to Ireland again and I lost a case, I just put my credit card in my shoe or something. That was my only hope in that moment. You usually have a lot of judicial hostility, like the average judge doesn't want to listen to privacy and all these issues. And the number of appeals is just too low to generate pressure. If you have, like Ireland, 10,000 cases and you reject all of them, and only one dude a year actually makes an appeal, it still pays off. You got rid of 9,999 cases without making a decision. So the whole system is pretty much stacked against you. We, as a nonprofit, can actually bring a lot of these cases and can move that forward. So I oftentimes say we're a bit like a snowplow. We kind of try to empty the roads so that other people can actually bring their cases later. But the DPAs are really a challenge. And that is a big part why the GDPR probably doesn't take off as we thought. The second option you have is you can do a civil lawsuit. You can go to a typical court. You have a couple of typical claims. What's really interesting that's upcoming is the emotional damages part. So the GDPR foresees that you have emotional damages too. And that was a big question how that is going to be interpreted. But the Court of Justice is actually quite strong on that. And for example, for a data breach, they say just the fear experienced by the data subject with regards to the possible misuse of his or her personal data is enough to give you emotional damages. So if you think you have a data breach, for example, which concerns 10 million people, and all of them just want emotional damages of 100 euro, which I guess would be reasonable. I'm usually a person for low numbers. That still gives you €1 billion. And that could get really interesting because I'm gonna get to the possibilities to merge cases in a second. So usually for jurisdictions, you have a lot of options there, so that's quite useful. In practice, you have a huge lack of knowledge. You usually end up in front of a judge that still prints out emails. That's basically who you're in front of to litigate that. They usually don't want to hear about that. They have a huge interest in rejecting these cases. They would have to learn GDPR, technical issues, and so on as a judge. So they find some reason to reject the case, some technical reason why it shouldn't be in my courtroom. We had one case in Austria that got rejected by the judge 3 times until she finally accepted that she has to listen to this case. So you realize that that is a huge problem with these hostile judges. Very high costs, so you may get damages of 500 euros. But bringing a case like that in a cheap jurisdiction costs you 20,000 euros. So you pay 20,000 euros to get 500 euros back. No one in the world does that. Usually the durations are also mixed. So the input-output ratio for civil litigation, not that cool. But what is really interesting is collective actions. So the European Union, there's a couple of factors when collective action actually makes sense. And usually you need large numbers of people, you need large claims, and you need very similar factual and legal issues. Then you can do a class action, so to say. And that's exactly what you have in privacy cases. You have one app that does exactly the same thing with all the users. And the European Union, I'm just jumping already to the front another time. We basically did that in Austria with a Facebook class action. We basically brought 500 euros each in unjust enrichment and so on. What was really interesting, we got that financed by a procedure financing company, and we got 25,000 participants within 6 days. Managed from my own little laptop back then. So you can actually bring these cases, and that really changes something. And by having all these cases merged into one in a two-party procedure, suddenly a lot of these dynamics I explained before go the opposite way. Suddenly it scales in text-speech, so to say. And this collective redress that the European Union has implemented last summer, and the member states partly still have to implement, like my home country as well, allows to have these cross-country collective redress. It's opt-in, so each person has to say yes. It can only be run by a non-profit organization, so not like in the US where some law firm just takes off and takes all the money. It has to be done by a non-profit. And costs, the law says costs may not be limiting factor. So the member states have to come up with some system that you can actually afford it. And usually you can do that with procedure financing. What you do is an app like that. That was our Facebook class action way back when. We even did a login with Facebook, so we could actually see that people actually have a Facebook account and their name and so on. So we love using technology for good causes. And with that, you can actually collect that and make cases that do make sense and also are financially viable. There's a bit of an option on the Article 80 of the GDPR where you can do the same thing in a different way. That's, I think, where a lot of the future lies in the litigation. Last but not least, what we do as well is mass complaints. So one big problem is a lot of the GDPR violations, talking, for example, about cookie banners, is very much mass violations. Everybody does it all the time. Most lawyers still work with a Word file, and then they type down the details of each website and do all of that. It takes endless to kind of bring a case against one cookie banner. So I thought about a bit more like a speeding camera. It's an automated system. They automatically figure out the license plate, the speed, all of that, and there is a printing machine that basically prints the tickets in the end. At least in Austria, that's how it's done. No one in the world touches that. It's fully automated. We looked at the biggest cookie banner provider that exists and realized all their configuration is actually an JSON file that's public. And you can just download all the definitions. For example, banner show reject all button false, which means do not show a reject button on the first layer. And with that, it's very simple to show actually the default configuration is that there should be a reject button, but you as the user of that service have actually deactivated that, which is perfect evidence to show how that works. The wonderful thing is the computer can automatically detect it and you get very precise information. You don't, even if you have a lawyer looking at the websites, they fuck something up, it's somehow not working. So we basically built a system which was more of the duct tape version of it. We're right now building the version 2, where we had an automated system that would detect all of that. We could automatically manage that and detect all these violations. One problem is, because of the law, we need to have an individual that actually goes to that website and is personally affected, because we need a claimant that actually on his personal computer got this stuff put on. So it's a bit more tricky, but you have to kind of capture all of that. But that worked really well. We basically did a PDF generator that automatically filled in all the details in a complaint. And what was really interesting is we then also sent them a compliance guide with really pictures of how the user interface from an admin perspective looks like. Click on A, then on B, then on C, then you're good. So we really put it on a silver plate for companies to comply with that. And what I was a bit proud of is we also did A/B testing with the emails that we sent to them, because we sent an email to the companies up front and told them, you know, you're not compliant, we give you 2 months to fix it, here's all the details. If in 2 months you haven't done anything, then we actually filed a complaint. Obviously all of that was for free, we didn't charge for anything and so on. But what was interesting is we tried four different versions of it. So a kind of neutral version, a friendly version, a bit pushy one, and then a very short version. And I was actually quite interesting that the pushy one was actually opened quicker and reacted to quicker, but then went down in the end. And I'm actually proud of society. The neutral one in the end won. But that is interesting because I think we can also, from a compliance perspective, take a lot of these nudging, whatever things that they do, turn it around and use it for actually complying with the law, which we at least started doing there. They then had a platform where they could log in and say if they complied or not. There was actually an option to then say, I'm done. And then we would basically tell them we ripped apart the complaint, we never see each other, which brought the enforcement costs extremely down for us. Like one case took us 2 or 3 minutes to go through, and all the rest was done by the computer, which for the lawyers is mind-blowing. Lawyers think Excel is magic, so this is beyond magic. What was really interesting is we got a 42% compliance rate just with this first email. So just by sending an email to the companies, we got 42% to comply with that, which is much better than all the graphs I showed you before if you actually go to the regulator. So that is quite useful for us. And the other thing we realized is we scanned about 5,000 pages, sent emails to the first 500 pages, and after the summer we thought we're going to continue with the next 500. Turned out all of them were compliant suddenly over the summer. We haven't even emailed them, we haven't told them anything. And there you have the domino effect where the company, the software provider, told them, watch out, there is a problem, there is now litigation. They added in their admin button a NOIP compliant settings button. So you could click one button to kind of fix all the shit in one go with our logo on it. I was like, that's cool. And that is exactly where enforcement works. And that's this general deterrence issue. When companies have a feeling that there is enforcement, that there is a consequence, suddenly it works. And that is the stuff that probably the regulators could take care of as well. We actually upgrade all of that. This is the kind of basic chart of this whole software system, but we're hoping that this is also going to move stuff forward. Last but not least, a lot of the end game will end up at the Court of Justice. The GDPR has a lot of elements that are unclear, and we see a lot of evidence generated against the meaning of the GDPR. So there's endless legal professors paid by big tech coming up with theories why the GDPR does not say what the GDPR really says. Obviously, that's all super independent research. And the only bullshit collector in all of this is kind of the Court of Justice that finally says no, 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 no to all of that. And that is our big hope, that a lot of the issues end up there. And we also bring a lot of the cases there usually. So we are engaged in a lot of these Court of Justice highest level litigation that hopefully gets us to a solution where some of that is actually complied with. I hope that was useful for you guys. Thanks a lot for listening in, and we still continue with the conversation as far as I know.
Yes, thank you very much. Also, welcome from my side. So I think it's very interesting. We kind of like collectively decided to call this event 5+ years of GDPR, its impact on data privacy. So now looking back, also looking forward, what do you see as the biggest challenge or the biggest challenges in enforcing GDPR compliance across the different industries that you can see?
Yeah, I think the biggest part is that what I had in the slides is this culture change. So the idea of the legislator in the EU was we just have hefty fines, big consequences, big thing, and they will comply with that. They will. They have not seen the the big tech and so on bubble that is just basically really doing the math of, is it more expensive to comply with this or not? And I cannot drop names because that is usually then somehow confidential, but even these big tech companies tell you that the privacy officers that oftentimes know that that's not cool what they're doing, tell you that their CEOs simply don't want to put down the money. Re-engineering stuff to be compliant, or probably also losing some money here and there, which in some cases is not even the biggest issue, but just the re-engineering work is not worth it because there is no enforcement. And that is, I think, where this culture change didn't kick in. They thought that just the threat of a penalty is going to be enough. And especially, so to say, the big tech approach, this kind of really, I explain it another way. I was actually studying for half a year in California, and our exams were, how likely is it that there's going to be a consequence? Like in Austria, the legal exams are, is this compliant or not compliant with the law? What is the consequence? But here it was a multi-factor, so to say, where you should factor in procedurally and from then, is there going to be enforcement? So it's a very aggressive way of thinking. We do that to a certain extent in Europe as well. I mean, everybody that crosses the red light, in the middle of the night does the same analysis of nothing is going to happen anyways. But this is done on a corporate level, on a very structured level. And the problem is the only way you can capture that is even more and more aggressive enforcement, which I'm not a fan of. I'm a fan of a liberal society where there's not, some police officer behind every corner enforcing stuff. But if the other side kind of tests the limits, you kind of have to step up. And that is, I think, where the European Union doesn't do that. And I have to add, that is partly political. I mean, we know from data protection officers, again, I can't, drop names, where they had to promise to their local governments, I'm not going to do too much, then I get the position. And that is what we saw in Ireland as a bigger thing. I mean, they also had that with banking regulation and many other areas, but also in other member states where, for example, a good case is in German in the state around Hanover, Hessen, no, Hessen is Frankfurt. Anyways, that state, you can find it out somewhere. They had a conservative head of the DPA, but she was replaced with another conservative head of the DPA. She wasn't even able to apply for the job again. She basically was just told, you're not the person anymore, now someone else is it. And the rumor was that this is because she didn't have her staff under control enough, because her staff actually did enforcement. And as a proper, head of a DPA that has his staff under control, you should make sure they don't do too much. And that is the dynamics we see partly, and that is on public record, so you can talk about that. And that is, I think, the biggest issue we have right now.
Listening to you, this reminds me very much of like Ron Swanson in Parks and Rec, who basically doesn't want to regulate, but faces all the complaints and requests to regulate, right? So he's doing his best to not do his job, right? But at the same time, I think there seems to be also a culture change, at least on the citizen level, that privacy is much more an issue that people care about. It's slow, but I think it's there. And I think this also indicates that consumers, because citizens are also consumers, are looking more and more into these kind of technologies and evaluate, do I care about this or not, right? But I think it's also a lot of parallels with the environmental movement, 70s, 80s, 90s, where we had laws against dumping your stuff into the river, and people were still doing it because they were hoping, like you say in data protection, well, if no one says anything, I'm just going to keep doing it, right?
Yeah. And that is, I mean, also from a legal perspective, I mean, one of the mind-blowing things for every law student the first semester is people don't comply with laws. Weird. That's normal to a certain extent. And as I mentioned, that's okay if in general people comply with it. I think one risk that we're running as the European Union is the one body globally that really passes legislation in the digital sphere. Because the US is basically unable to publish or pass any legislation anymore. They can't even pass their budget. The member states individually or smaller states are too small. If Austria passes someone, they would just say, okay, we're not providing the service there anymore. Australia did that partly, where they just said, okay, we're not providing the product in Australia anymore, and then look what your citizens are going to say. So that is really, you need a big block basically to do that. So I think the EU is in a unique position there, and quite interesting. I don't think all the legislation that comes out of it is necessarily smart. I think the GDPR could be half as long and still do the job better. But we're at least moving there. The big problem is, are we becoming the laughingstock? Because if basically there's all these big promises and then no consequences, you run the risk that you get into exactly that situation. And that is a bigger issue. It's not only privacy, it's not only, as you said, environmental laws or so on. It's a question of, do you legislate too fast maybe, that it takes too long for the society to even adapt to that? Are you not enforcing it enough? So I think that's a lot of the questions we have to raise, where I'm not an expert on. I can just basically show the problem. The higher level thinking is maybe for more political experts on how you do that better. What we see right now is that it mainly lacks on the executive side. To explain that as well, the data protection authorities are independent by law. They're independent from the executive. Sounds wonderful, but what does that mean? Is you can appoint the Irish DPA for 8 years, and then as a Minister for Justice, you can say, oh, I didn't know that Helen Dixon wouldn't do her job, but I can give her orders, she's independent, I'm very sorry. So the executive oversight, which usually in a democratic society we have, where ultimately some minister or so is accountable, is gone. then the legislative oversight does not exist. I mean, she was called into the European Parliament and she basically said, I don't appear unless I can basically decide what the questions are, which the European Parliament was not all too impressed about. But so this legislative oversight does not exist. Third option is usually the judicial oversight, which, as I mentioned, costs up to 100,000 euros, so that doesn't exist. So the fourth option that you usually have is public. So we went out to the public, showed the decisions, do media stuff, and so on. What did they do? They passed in Ireland a law making it illegal to talk about a pending procedure in front of the DPA. So I right now run the risk, because they haven't passed a decision under that law yet, but they're basically criminalizing criticism at literally that level. They obviously said it's about the confidentiality of the procedure and blah, 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 blah. But the reality is that that's the fourth option you had, and that's also, there is a closing factor on that. And craziest shit ever, there is a new procedural law that the European Union tries to pass, and there they put in that all the procedures are confidential. And these procedures take 10 or 15 years. So for 10 or 15 years, you're not allowed to say what Facebook says, why they can have your data, which they should even put in their privacy policy. Like, that's part of the GDPR, to be transparent and tell everybody what you do with their data. But then they say all of that is confidential. And that's the next option to limit any kind of criticism or pressure.
And yeah, I mean, listening to you now and also to the presentation, it's very clear there seems to be a lack of political will is a very nice way to put it. It seems to be outright obstruction, right? To make it as difficult as possible for you to enforce your rights. And I think this is rather bleak, is filing legal complaints, going to the DPA, and then they make it difficult for you to go to the DPA. Are these really our only options?
In the legal system, yes. I mean, you can bombard them or kill them or something, or do, like, I don't know, rip out their computers. In a proper legal system, that's the options. I think what we need is awareness of the situation, because right now, and I have to put a big asterisk, there are DPAs that do quite a good job as well. Like the CNIL, for example, in France, is usually enforcing quite well, despite not listening into complaints. That's their problem. But for example, one that's super underestimated is the Spanish DPA. They pump out 8 or 9 decisions a day. We can't even follow their decisions, so many. Which is interesting. They have the same budget than the Irish and about the same headcount. They pump out as many decisions in one day as the Irish do per year. Just imagine that. So it's not just about them having more resources, which they usually say. It's also a question of efficiency, of how to, as a regulator, be efficient. And there are DPAs that try to work on that and go in that direction. The Norwegian DPA is a very good example. They're not even EU member. They're part of the European Economic Area. But they actually leverage all the options that they have to kind of leverage the European bubble to actually move stuff. So there are some that actually do that, but not a lot. And I think that is where we may see changes, but also the other direction. We saw when DPAs were more active, then politics intervened to stop them being too active and appointed someone else. So it's a balancing act for them as well.
Right. So you started out the presentation with talking about the notion of consent, right? So I actually wanted to come back because I think you have been critical of the notion of consent as a legal basis for processing people's data, right? Whenever I think about this, I find it quite difficult because it kind of turns privacy right as a universal right into something that's a negotiable commodity, right? It's some things that I can purchase, I can give away. And I think we can see this in the meta consent or pay issue that's going on right now. And I find it very disconcerting because basically I agree to my data being collected and being sold to third-party people, or I have to pay for this, right? On the other hand, I have to say, well, these companies also have to get money, right? You can't have a product for free. So in between those two standpoints, where are you coming down?
So let's start at the very beginning. I think the right to privacy inherently needs to have something like consent, or with every fundamental right, you have a right to waive it. If you have a right to property, you can throw your property away if you know what you're doing. That's fine. I think in a liberal society, we will need consent. The idea of the GDPR is that 99% of the processing is legal anyways, because you have 6 legal bases. Consent is only one of them. Consent is, however, the only one that the user ever sees, because that's the only time you're asked. So all the other 5 legal bases happen all the day, but you just don't realize it. And in my ideal world, most of that stuff should be done only in the situation where they really do something where they don't have a right to do it. They need to ask you for consent. Now, you have this problem with inflation of consent, and a large part of it is that the GDPR does not regulate, or generally we don't have a regulation on that. is how to do interfaces that are not nudging people into buying shit, into consenting to shit, into, you know, long list of stuff. So I think we probably need some talk about interfaces. What we used in the GDPR, there is a word that the processing has to be done fairly. And we're like, if you hide the consent button on the 5th layer, I don't think anybody finds that fair, so just say. So that is for the consent general thing. Now, if you move on to the pay or okay situation, it was started by an Austrian liberal newspaper. When the GDPR kicked in, they came up with this idea of payment. Why they did it was mainly to push their subscriptions, not for the whole argument that really comes up. The idea was, we need to have this huge banner on every page now. Let's use it for advertisement. The one where you consent to advertisement is itself advertisement for our subscription. Really smart idea. Like, I know the guy that came up with it, I was like, not bad, not bad, I have to give it to you. Now, what the real problems are is a couple. The first element is the amount you're asked to pay is usually 200 or 300-fold the value of the data. So we know for Standard, that newspaper in Austria, that they make about 4 cents for personalization per user per month, roughly. Like, their numbers are half public, so make it 10 cents, just for the sake of the argument. They ask you for €8 to not have the advertisement. So they overcharge you tremendously. So already on this economic argument, which is their main argument to say, oh, we need to make money, we calculated if the 2 million users they have per month would all pay €8, they would be the richest media company of Europe. So the amounts are already quite questionable. The interesting part, if you discuss it on the amount side, is Meta actually makes almost that much money per month. What would that mean if we basically only do it on the economics of it? It would mean that the more money you press out of data, the more you can ask to pay for the consent. So basically, you have a negative spiral. The more money you press out of it, the more you have to pay to not be pressed out of it. So basically, you can in the end pay €100 if Meta makes that much money with the data. So that's questionable. The GDPR itself actually says consent has to be freely given. So you must have a genuine wish to say yes. That's kind of the idea of the law. And I think the best way to deal with that is statistics. We know that, depending on statistics, 3 to 10% actually want to have consent. If 99.9 actually give consent, then that's probably not a genuine free choice. I mean, I'm gay, so I'm allowed to say that. If I go to a discotheque and ask 100 girls if they want to fuck with me, 3% say yes, but in the end 100% have intercourse, then that's called rape. and that is pretty much the situation we have here as well. There is no free consent to all of that. So I doubt that that's really true. Problem is, the regulator said yes because the media companies did it the first, and no one wanted to touch the media because they're struggling anyways, they don't get money. So that was kind of how that was shoehorned in, is to say, oh, if the media companies do it, we say yes, and then everybody else, you can't say no because the GDPR doesn't differentiate, and that's kind of the story of pay or okay. Last sentence on that, the Court of Justice actually mentioned the option to pay in a judgment last year, in a case where no evidence was brought forward before the judgment, before the court, no argument was made, as far as I know from the people that were actually doing the litigation. Some judge must have spitted these 6 words into the judgment, where they say, maybe against the fee, but in a whole context that says freely given. Facebook now relies on these 6 words. I would say read the whole context of the judgment, but I think we're going to get a second judgment by the Court of Justice on this, and then we'll see where it goes. But if it comes around, everybody can ask you for an extra fee. Every hotel can say, want to sign up to the newsletter or pay €10 more? Every telco provider can say, can I have all your connection data or pay €50 instead of €10 for your cell phone account? Like, there would be no limit. So I hope that they come to the realization that that's where it goes. Right now, the DPAs are a bit split. There's going to be a vote the next couple of months, so the next 1 or 2 months, where we know what the DPAs say. But that will go to the Court of Justice anyways, so we'll see where we end up there.
Right. And I think it's good that you pointed this relationship also with the tech companies out, because I think there's a huge power imbalance. We see that Meta can afford to do that. because it has the networks that are really important for content creators, for many companies, for any advertiser personally that rely on having access to this network, right? In smaller websites, if they, or hotel, as you suggest, well, I just don't go to this hotel. I just say, it's just no.
The interesting part is not, in many ways, I was just in Miami 2 weeks or 3 weeks ago. You go to the hotel, you order the hotel, you bought everything online. Then you go to the desk and they say, there's a $35 resort fee per day. Now it's 11 o'clock at night and you're at that hotel, you booked that hotel. Who is going to walk away? I mean, in that case, I knew there was a resort fee, it was already a booking thing, but that is exactly how they do it. And that same thing is going to be like, are you going to walk away at 11 o'clock at night over 10 euros versus consent to a newsletter? I don't think so. And there are many, there's the network effect, which we have for big tech, but there are many other industry sectors where you have a similar situation. Or even for the newspapers, in Austria, almost every newspaper does it now. So where else do you go? It's just like a reality then. And there is even a software vendor in Germany, which is Consent Pass, that basically sells that as a product now. So you have hundreds of websites that do it. Yeah.
Yeah, and I think this is exactly when this scales, when this model becomes something that everyone can do, we get squeezed out of money for almost everything. At the same time, these big companies, these platforms rely on the network effects. So in the beginning, you always have to be free. And once the critical mass, the dependency, somehow the economic value is achieved, you switch on the mode. And we see this with many things. And mind you, I'll predict ChatGPT will also be for payment soon. Like it will happen. It cannot go free forever. Or we get advertisement. These are the two options, 100%. My last question, since I want to move also to the audience questions. Now, considering also the very rapid development, and I just talked about ChatGPT, but just artificial intelligence in general and IoTs. How do you think data protection laws like GDPR need to evolve to address these new privacy challenges in these technologies? I don't know if you remember, 2022 was a very interesting MIT review article about Roomba taking pictures unbeknownst to the owner in Venezuela who was on the toilet. And these pictures were taken, saved, processed by the company behind it, and somehow ended up on Facebook. So there's one question about how this picture came up to Facebook, but no one knew that actually Roomba is taking pictures of you and they go into a data company where we don't know what happens with it. So this is my question. How can is GDPR future-proof for AI and IoT?
One fundamental thing about the GDPR to understand is I usually explain it that way. It's a raw data law. It says, can you have data? Can you process it? For what purpose or not? It does not really specify how you process the data. That's what they call tech neutral. So that is what the GDPR does. When it comes to AI, we haven't had many cases. We probably bring a case in 2-3 weeks. I can't say too much about it yet, the first one, but we don't see it in consumer products that much yet. So there's a lot of hype, but on what's lands on our desk, we don't see it that much yet. We see picture generation and so on, but not really processing user data. That will come up in the next months or years for sure. What's interesting is the AI Act. I'm not an expert on it, so I'll shut up. From the GDPR perspective alone, what's interesting is a couple of elements. First of all, for example, data about individual people has to be accurate under the GDPR, just like the credit ranking example I had before. Now, if I type in, for example, what's the date of birth of Max Schrems into OpenAI's ChatGPT, it gives you some random date. You would have a right to actually have rectification there under the GDPR. How do you do that in an AI system? If we say we do credit ranking with an AI system and it hallucinates that you didn't pay your bills, you have a very direct consequence, and as the person running the system, you will pay the damages caused. Give you an example, if maybe you got the credit, but you got a higher rate because the bank thought you're a higher risk. If that is an 1 million euro that you took out for, I don't know, building a big fancy house, that is hundreds of thousands of euros over 20 years paid back, that 0.5% more that came out of some AI actually cost you in damages. So that will be quite interesting already under the existing GDPR rules. Who is liable for that? Can you use it on decisions that are that relevant, that actually have a consequence? My answer right now, probably not. Even when you talk about the right to access, I ask OpenAI for access to the data that they have on me, because if I ask a question about Max Schrems to their ChatGPT thing, there comes some information out of it. So there must be some information in it. If you make an access request, they tell you the way a neural network is designed, we cannot give you access to whatever is in there. So that's going to be really interesting how that complies. Obviously, the AI Act would then be more specific for that. And again, I'm not the expert on it, so I shut up. But I think already on these elements, the typical GDPR logic would already cause some troubles. Not saying it's not a useful tool. At the same time, we also try to, for example, summarize judgments with systems, which usually led to them telling me exactly the opposite of what the judgment really says. But let's say that will be improved and works better in a year or two. That may be use cases that are quite useful and make sense. If it's really, on an individual person generating information at the level it is right now and probably for the foreseeable near-time future, you'll probably run into some GDPR issues alone, let alone the whole AI Act and other regulations that exist.
All right, thank you so much. So I think I would like to take another 10 minutes before we're closing the event to have the audience pose questions for Max. Right, I see immediately hands going up. So 1, 2, 3, I already saw. So first hand, the nice gentleman in the green shirt is coming up. We have, we need an, Margot's on the way. Perfect, thank you.
Thank you for the excellent presentation. So my question is, I don't know how many DPAs are there in Europe, maybe 27 plus or minus, and you were saying that there's 300 million euros pumped in to these. If we look back at Safe Harbor and Privacy Shield, why was it NOIB that acted there and not the 27 authorities? Is it like, do they lack competence to act over it and you have more freedom, or?
They simply didn't want to do it. So we actually brought 101 complaints at the time. So we also scanned for websites that used Facebook Pixel and Google Analytics, because we thought that's easy to uninstall, just to take some example. And we brought these cases 101, and happened to be 101, so we had 101 Dalmatians as our picture, because that was easy. And we thought, okay, let's see what the DPAs do. We brought some cases with each DPA. None of them, I think one enforcement happened in Sweden after 3 years. None of them issued a fine. None of them even touched the case. Most of them didn't even touch the case. So in most cases, they negotiated with the company to stop the processing and then said, okay, it's fine, don't worry. That's the enforcement that happens. And that's interesting because that's a case where, as you mentioned, the Court of Justice already told them twice what the law is. So how much more do you want to hear? And then you simply see that on the enforcement level, it's just not done. And you're exactly at what I mentioned before. The cases were right in front of them. They had all the evidence right in front of them. You could have written a decision in 2 days with the stuff that we provided. There's just no willingness.
Right. Then,
with a little asterisk, there's a couple of DPAs that did individual investigation in some cases.
All the way in the back, the lady with the yellow scarf. Yes, Margot's on the way.
Thank you very much for the talk and the comments and also the anecdotes. Very insightful. You talked a lot about big tech and that they have no incentives or motivation to re-engineer their systems to actually comply. But the problem is now we're actually seeing moves by Google a lot towards federated analytics, federated learning, or the Google Topics API, which is like their privacy-preserving alternative to third-party cookie tracking, right? And one might argue that that actually might lead to compliance with GDPR. It might actually limit tracking. But then, do you think that actually solves the problem? Because the problems of targeted, personalized advertising are things like price discrimination, or that females are much less likely to see executive job advertisements. And so what do you think needs to change that we can capture also this problem of, like, even if they now have found ways to become compliant, but don't actually prevent the problem?
My problem with the question is that the premises, I think I would disagree, because they haven't found a way to be compliant yet. With the Topics API is a wonderful example. What did they do? They basically said, now it's not the server tracking you anymore, now it's your own browser tracking you and analyzing what you're interested in, and then the browser tells the website what you're interested in. From a GDPR perspective, totally irrelevant. Like, I know it's like more privacy preserving because not on the server. agreed, yeah. But that's a bit like, it's less of a murder, but the person is still dead. So like, you know, it's like a nicer way of killing. And so with a lot of that, what's really interesting is what they beefed up with is the PR. Is, you know, one interesting thing about this case is that they actually had a pop-up saying, do you want to have this privacy-preserving technology installed in your browser? Usually you would think that's an ad blocker or something that blocks all that shit, which is usually what you would install in a browser to improve your privacy. And it was sold that way. What actually that button was consent to your own browser tracking you. And this reframing is something that we saw is working really well. That is their reaction to GDPR, is to find ways of saying, oh, we take care of it, and it's then the average journalist just copies it over, you read it in the news, it's just then, it's the same thing that Trump does. It's basically just blowing out there is no privacy. My best example for that as well was, for example, Microsoft, after the data transfer decision, said we now have privacy-preserving, wonderful, blah, blah. One of their big talking points is the data is now in the European Union. Totally irrelevant, because US surveillance laws have a global reach, and unless you physically separate it, you can still have access to it. Or they, for example, said you get damages if you can prove that we actually gave the data to the NSA, which you can anyways. But funny thing is, you get these damages under the GDPR anyways. And they sold that as a supplementary, wonderful privacy thing. So what we see in many of these cases is more PR stunts and selling stuff than really changing much. However, again, with little asterisks, it depends on the culture you're in. When you come with a GDPR European mindset, then it's not a solution. If you come from an American mindset where there's no law at all, then yes, this is better than what we had before. So there is also different realities, so to say, or different parameters where you look at it. But from a European, or at least GDPR parameter, we didn't really get to that too much. I hope that's somewhat useful.
Right. Then there was someone here in the front that I saw early. Yes, the lady in yellow, right here. Yes.
Many thanks for the conversation. I have a very simple question. When you accept the functional cookies, how many of your personal data you give away? And when you don't have the interface, refuse all, what do you do?
So how much data depends on how loaded your browser is. So for example, my browser deletes everything every time I close the browser, so it's pretty much a virgin browser that they try to kind of follow around. If you have a browser that already got loaded up with information and tracked for 3 or 10 years, then you automatically give up much more information with that. So that depends on your specific situation. To say no, usually there has to be a no option. It's just hidden usually. What's interesting, let's say from a normal user perspective, is there are no plugins that automatically hit the no button. There used to be a plugin that automatically hit the yes button to not get on anybody's nerves anymore. There's now also plugins you can install in your browser that automatically hit the no button, and thereby get at least that blocked. And that usually works also, that the cookies are not placed once you hit the no button. One problem that we have is a lot of the companies claim that some of the tracking is an essential element of the website, and then no matter what, if you click yes or no, the tracking will run anyways. So usually the best option is to choose, at least in my experience, is to choose a plugin that just blocks all that shit. Plus, for example, I just delete all the data in my browser once I close it. But that has usability issues. Like every time I go to, like as an Austrian, for example, you search for legal questions, always get the German answers because that thing doesn't know I'm Austrian, and I don't care about German law in that sense. So you do have these problems that come with it. I hope that's somewhat useful as an answer.
Right. So we have time for 2 more questions. Can I identify some more students? Yes, so the gentleman up there. Fantastic.
Hi, thank you very much for the talk, first of all. I had a question considering like the big discrepancy there seems to be between the adoption rate of the GDPR at the parliament with like 90+% adoption, and in effectiveness, how the DPAs do not seem to do anything at all. So I was curious to have your point of view between like the eagerness, the initial eagerness of it all, and the follow-through about the GDPR, and like its enforcement?
Yeah, so basically we have the e-governance on a European level, and we had it by most member states as well when it comes to the legislation. Once you have the legislation in place, you have the issue of local interest. So if you know, take Ireland as an example, take Luxembourg as an example, whatever, if you know you're not enforcing rules A, B, C, D, E, F, G, you make your position in Europe for big companies, usually for international companies that can choose where they want to be, much more attractive. And that is the system as it runs. And it's not a GDPR specific issue. In Ireland, what was really discussed publicly a lot was banking regulation. They did not regulate their banks. They really didn't look for stuff. Then in 2008, when we had the financial crash, their banks crashed even more than all the other banks, and they had huge financial issues. Which for the first time brought up a public debate about, is it that good not to regulate stuff? And I don't know how much it's true. I recently saw a documentary by a public broadcaster about Ryanair that is regulated in Ireland. Turns out not that many inspectors want to see a Ryanair plane versus how often, I don't know, a Swiss plane is inspected or a Lufthansa plane is inspected and so on. So overall, that makes a place more attractive for business. There's a very dry, terrible joke in Germany is like, how do they call it in Bavaria, that there's less tax inspectors in Bavaria, apparently that's a thing, is good for business. Because if your taxes are not inspected, you get away with more. And that is the logic that then in the second round basically caught us. And that is a problem that I think any federal system realizes. A good example is the US. They didn't have the FBI or something until 100 years or even less ago. Then they realized, if you just go across a border and you get away with murder, that's not a good idea. So they federalized a lot of these enforcement. And I think we're probably going to get to that in the European Union as well, because especially the international companies, and that's the reason I mention them a lot, they have the option to just cross the border and go somewhere else. And increasingly so. And we have the problem with taxes. We have the problem with many other areas as well. And privacy is one of the situations where this larger problem materializes quite dramatically with all these consequences. But yeah, I hope that's useful.
Right. Sorry, I was very blind on this side. Is the chair. I'm sorry, the chair poses me like this. Turn around, here were hands up. One last short, brief questions. Lady, yes, please.
Yes. So servers have this robots.txt file, and crawlers need to comply to that. For instance, the Internet Archive cannot archive web servers if they have no for that. Why people cannot have this in their devices to protect themselves, and we just need to answer the question of others?
Thanks a lot for your question. So the GDPR actually foresees that in 2 articles, that there could be electronic communication between your device and the server saying, I don't want that shit, go away. Funny thing is, the law does not say how that should be implemented, what the standard should be. So it just says there should be the option, miraculously, but what is the signal you're sending? Where is it defined? Now, we had this whole discussion about the do not track header signal, so to say, which was in the W3C. Then the whole industry came in and found 100 reasons why we cannot put this one bit into the header, or this 1, 0, or 1. And basically killed it. The interesting thing could be in e-privacy, there was a discussion to have that, which is another regulation that regulates the cookies, to have that signaling. And we even had a project on that to show to politicians that's doable. It's not magic, you add a header line. That's like anybody that in the room probably knows how that works. So we showed it even, and they were like, oh my God, it's like, that's a header and that's how it works. So the knowledge is really missing. And the problem, especially in Brussels, is that there is tons of lobbying and tons of lobbyists, but they usually have no clue. And I'm sitting in these rooms oftentimes, it blows your mind what they say. And if you're working in that space, there's a lot of opportunity to just go to Brussels. It's easy to get in, it's easy to be heard, it's easy to just call up a member of parliament and say, hey, I have an idea here. Or the access is really there, you have to say. The problem is the access is only used by lobbyists, and they usually have no clue about it. They're not even bad faith oftentimes. They just don't have the idea of how to do that. Oftentimes it's bad faith then as well if it comes to the big tech companies. But there is a lot of opportunity and the discussions exist. We showed it as well. We called it Advanced Privacy ADPC or something was the name for it. You can find it online. We did a prototype and so on, and that would be a very simple solution for the whole problem, and one that was actually also catching interest by politicians, because everybody hates cookie banners. No one in the world wants to have cookie banners. So to have a solution for that would actually be appealing, because as a politician you could say, hey, I solved cookie banners, everybody hated it. But right now the knowledge is simply not there and the know-how. So especially for the audience here, if you're interested in such solutions and working on such stuff, the EU would be a very interesting place to put that and put suggestions for it, especially now with the new European Commission coming in. They will have their new agenda, their new 4-year program. So a lot of these things can be put forward if there's good research on it, if it's not just put on. I know people love to be in a journal. No one in Brussels reads a journal. You need to also then send it to the people that make these decisions and say, hey, we did some research, we had a good idea. Why don't we want to implement that? And this could be a way to do it. And there is a lot of opportunity and even like vacuum that you could fill there. So if anybody's interested in that direction for all topics, not just privacy, it's pretty accessible. I mean, I was just asked to sit on a panel in the European Parliament as a student and sat there and was like, this is shit, you should do something. And apparently I said it's somewhat reasonable, so they invited me again. So there is quite an opportunity there.
All right. Thank you, Max. Thank you very much for your lecture. Thank you for this super engaging talk. We're very happy to have you here. Also, thank you to the audience. Thank you for coming. Thank you for staying 15 minutes later than we were supposed to, but it was also very interesting, and I didn't want to cut you off just for the time being. So thank you for your patience and for your questions. Again, this is campus lectures organized by C4DT, Center for Digital Trust. You can find out more about our interesting events when you come to our website, and you can also follow us on LinkedIn. So thank you very much and have a great evening.
Thanks a lot, everybody.